These 5 legal mistakes cost Florida residents everything. Avoid them. Every day in Florida, ordinary people lose their homes, their money, their custody rights, and their freedom, not because they broke the law intentionally, but because they did not know what the law required. These 5 legal mistakes are completely avoidable. Here is exactly what every Florida resident needs to know right now. Why legal mistakes happen to good people. The most dangerous legal mistake is assuming that common sense and good intentions are enough to protect you under Florida law. They are not. Florida has specific statutes, deadlines, procedural requirements, and legal standards that operate independently of whether you meant well or acted in good faith. The law does not grade on effort. It applies equally to everyone, and ignorance of the law is never a legal defense under Florida or federal jurisprudence. The 5 mistakes covered in this video span the most common areas of Florida law where ordinary residents suffer serious and completely preventable consequences. Estate planning, criminal procedure, contract law, family law, and real estate law each contain legal traps that destroy lives every year in Florida courtrooms. Understanding these mistakes before they happen to you is the entire purpose of this video. Mistake 1: Dying without an estate plan in Florida. This is the single most widespread and most costly legal mistake Florida residents make. According to consistent surveys of American adults, the majority of people do not have a will, let alone a comprehensive estate plan. In Florida, dying without any estate planning documents in place means dying intestate, which triggers Florida's intestate succession laws under Chapter 732 of the Florida statutes. Florida's intestate succession formula distributes your assets according to a rigid statutory hierarchy that has nothing to do with your actual wishes. If you are married with children from a prior relationship, your surviving spouse and your children split your estate in a division that frequently creates conflict, litigation, and family destruction. Under Florida Statute 732.102, if you die leaving a spouse and children who are not also the children of that surviving spouse, your spouse receives only half of your intestate estate. Your children from the prior relationship receive the other half regardless of their ages, their needs, or your intentions. If you die without a will and without a trust, your estate must pass through Florida probate under Chapters 731 through 735 of the Florida statutes. Probate is expensive, public, and slow. Statutory attorney fees under Section 733.6171 are calculated on the gross value of your estate. On a $400,000 estate, those fees alone can reach $15,000 or more before accounting for court costs and personal representative fees. The solution is straightforward. Every Florida adult regardless of age or wealth needs at minimum a last will and testament executed in compliance with Florida Statute 732.502, a durable power of attorney under Florida Statute 709.2101, and a healthcare surrogate designation under Florida Statute 765.202. Adults with real property, minor children, or assets exceeding $75,000 need a revocable living trust under the Florida Trust Code at Chapter 736 to avoid probate entirely. These documents cost a fraction of what probate costs and protect everything you have built for the people you love. Mistake 2: Talking to police without an attorney present. This mistake destroys criminal cases every single day in Florida courtrooms. It does not matter whether you are innocent. It does not matter whether you have nothing to hide. Talking to law enforcement without an attorney present is one of the most legally dangerous things any Florida resident can do. Under the Fifth Amendment to the United States Constitution and Article 1 Section 9 of the Florida Constitution, you have an absolute right to remain silent when questioned by law enforcement. Under the Sixth Amendment and Florida Rule of Criminal Procedure 3.111, you have the right to have an attorney present during any custodial interrogation. These rights exist specifically because trained law enforcement interrogators are skilled at eliciting statements that can be used against you regardless of your intent. Florida courts have consistently held that statements made voluntarily to law enforcement, even before a formal arrest, are admissible as evidence. A statement that you believe is helpful or exculpatory can be twisted, taken out of context, or used to establish elements of an offense you did not even know you were being investigated for. Florida Statute 901.151 governs investigatory stops, and many Florida residents do not understand that they are not required to answer questions beyond providing identification during a lawful stop. The correct action in any police encounter involving questioning about potential criminal activity is simple and consistent. Clearly and calmly invoke your right to remain silent. State that you want an attorney present before answering any questions. Then stop talking. Do not explain. Do not justify. Do not argue. Every word spoken after that point is a risk that serves no legal benefit. Mistake 3, signing contracts without understanding Florida law. Florida residents sign contracts every day: lease agreements, contractor agreements, employment contracts, purchase agreements, financing documents, and countless others, without understanding the legal obligations those signatures create or the rights they may be waiving. Florida contract law under Chapter 672 of the Florida Statutes for Goods Transactions and Common Law Principles for Service Contracts enforces what you sign regardless of whether you read it or understood it. 3 specific contract mistakes cause the most damage to Florida residents. First, failing to include dispute resolution clauses that specify Florida as the governing jurisdiction and venue for any disputes. Without these clauses, a dispute with an out-of-state contractor or company can result in litigation filed in another state under another state's law. Second, signing contracts that contain binding arbitration clauses without understanding that these clauses waive your right to sue in Florida civil court and limit your remedies significantly. Third, failing to document contractor agreements in writing before work begins, which leaves Florida homeowners with no legal recourse under Florida Statute 489.126 when contractors accept deposits and fail to perform. Florida's Statute of Frauds under Florida Statute 725.01 requires certain contracts to be in writing to be legally enforceable. Contracts for the sale of real property, contracts that cannot be performed within 1 year, and contracts for the sale of goods over $500 under Florida Statute 672.201 must be in writing. Verbal agreements in these categories are generally unenforceable in Florida courts regardless of what was promised or what both parties understood. Mistake 4, mishandling child custody and support in Florida. Family law mistakes in Florida can have long-term consequences, especially for children. 2 of the most common errors involve custody changes and child support. Under Florida law, parenting plans can only be modified through court approval after a substantial, unanticipated change in circumstances. Informal custody agreements have no legal value and can lead to serious consequences if disputes arise. Similarly, child support must be court-ordered to be enforceable. Informal payment agreements cannot be legally enforced or collected later. To protect your rights and your child's future, all custody and support changes should always be handled through the proper legal process. Mistake 5, misunderstanding Florida's landlord-tenant law. Florida landlord-tenant laws are highly specific, and violations by either party can lead to serious financial consequences. Landlords must follow strict rules for handling security deposits, including proper storage and providing written notice within 30 days. Failure to comply can result in losing the right to claim any portion of the deposit. After a lease ends, deposits must be returned within 15 days or deductions must be reported within 30 days. Tenants also make mistakes by failing to give proper notice, abandoning property, or withholding rent without following legal procedures, which can weaken their legal protections in disputes. Conclusion. These 5 mistakes share one common thread. Every single one of them is completely avoidable with proper legal knowledge and timely professional guidance. Florida law rewards preparation and punishes ignorance consistently and without exception. The cost of preventing these mistakes is always a fraction of the cost of fixing them after they occur. Estate planning protects your family before a crisis arrives. Knowing your constitutional rights protects your freedom before charges are filed. Understanding contracts protects your money before a dispute arises. Following family court procedures protects your relationship with your children before informal arrangements collapse. Knowing landlord-tenant law protects your property and your deposit before a tenancy ends badly. Subscribe for more real Florida legal guidance, because the best legal protection is the knowledge you have before you need an attorney.